an official announcement that this is a copyrighted broadcast of copyrighted by Boreen Law Firm. No reproduction or sharing of it is permitted without the consent of Boreen Law Firm. But if you want to get a consent to rebroadcast it, contact Boreen Law Firm. Thank you.
All right, thank you, Scott. All right, so we're gonna start. So my name is Miho Patani. I'm Assistant Director in the office. Thank you all for joining today's session. Before we start our session, we have a couple of housekeeping announcements to make. You should be muted. I think you all are during the session. You can submit your question in the chat box during the presentation. Scott will be presenting different options available for you after you graduate from St. Thomas. So first hour will be Scott's presentation, and the last 30 minutes will be having a Q&A session. All right, during Q&A, we'll go through the question that was submitted in the chat box in the order of the submission. So if you can just keep muted yourself during the presentation, that'd be great. Let's see. All right. So I would like to find out who are our participants today. So if you can just answer the poll, that'd be great. All submitted, right? Oh, 80% voted. Oh, that's a grad students. Oh, we have a OPT, STEM OPT students as well. All right. So Scott, we have about 4 undergrad, 9 grad, and 4 OPT and STEM OPT students.
Great, thank you. Good mix.
All right. Okay, so I'd like to introduce our guest speaker tonight. Scott Boreen leads a 7-person Boreen law firm in Minneapolis, a leading US immigration law firm. He personally has more than 35 years of experience helping F1 and J1 students and scholars, college and universities, and employers to obtain work visas and green cards. The firm has extensive experience helping individuals and employers of all sizes, from startup companies to Fortune 500 corporations. Scott has been recognized by the other lawyers as Minnesota Lawyer of the Year in Immigration Law of 2020, 2018, 2016, and 2012, as noted by the best lawyers in America. Scott has been repeatedly recognized by the other immigration lawyers as one of the top 20 lawyers in the world, most highly regarded in the corporate immigration law. Scott was awarded a NASA Distinguished Service Award in 2003 for his many years of immigration help to international students and scholars, DSOs. DSO is like us, and the US colleges and universities. He is a graduate of Harvard University and William Mitchell Law School. All right, please join me. Welcome, Scott.
Thank you. Thank you for the nice introduction, Miho. Can everyone hear okay? If you can't, wave or throw something or whatever. I'm assuming that I can be heard. Okay, so we won't go to the slides just yet, Miho. I got a couple of things I wanted to do first. I wanted to, I'm not a Greek, but I studied a little bit of Greek when I was in high school, actually, but I come bearing gifts. So some free things for anybody that's on this call, or any other students or graduates or members of faculty or staff at St. Thomas. They can, questions will occur to people, after the session's done or whatever about immigration. And if an in-person setting, I just go out and talk with people in the hall or whatever, and it's at least semi-private. But if the person wants to have a private, confidential discussion with me at no charge, for 10 or 15 minutes. The magic word is mini, M-I-N-I. You can call our office at 612-321-0082 and say that you're a student or a graduate of St. Thomas or a faculty member, whatever, and that you would like to have a mini appointment, a no charge mini appointment. It was mentioned in the presentation. And then at a mutually convenient time, we'll have a chat for 10 or 15 minutes at no charge. Sometimes situation that the person that calls and asks this question during the mini is more complicated, requires seeing more documents, and takes a lot more than 10 or 15 minutes to really adequately discuss. In that case, usually the next step is to set up a consultation appointment, which is nowadays it's until the virus is gone, which the governor says maybe later this summer, that it will be a telephone consultation. We normally charge $400 for that type of a 1 hour initial consultation, but for students, we charge half that. It's 50% discount, so it's $200. It's the same consultation, but if you're a student, you only have to pay half cost. Then the other thing is that as anybody that is getting this message, or it wasn't the thing today, but would like to get it, I'll be referring to various immigration developments, and we publish an emailed, used to be snail mail, but now it's an emailed newsletter of just about like monthly, sometimes do a combined issue, but 10 or 12 times a year of immigration developments. And I always like to put in things related to students and H1s and universities if it fits in. And most months there's at least one item that's specifically about that. Other things are about changes of immigration law in general. That we've got a new president now. I'll be talking about some of the proposals with that. But anybody that wants to be on that email list, and you can get on or off whenever you want, you could either call our office and ask to be on the email list, or you could send an email you can go to the firm website and then say you want to be on an email list. Or if you get in touch with Miho, I think you would, if I wouldn't be putting a burden on you, if people want to send their email address that want to be on the free subscription list, then Miho will send it to me. Is that okay?
Yes. Yeah,
okay, so that'll work.
Send me the email, okay?
Okay, great.
And I will forward to Scott later.
Great. Okay. Then as prior to the call today, or maybe contemporaneous with it, I sent some information in a packet that was, if it were in person, I would hand these out. But since it's actually maybe more convenient for some people that it's electronic version, but it's called After F1 What every student needs to know about H1 work visas, green cards, and other immigration options. And I'll be referring to some of the things in here from time to time. It has four main parts. One is frequently asked questions about H1s. Another one is an article called Professor Yes, Immigration Options for Professors and Researchers. We do a lot of work with people that are faculty members and researchers, but that article, in spite of the title, if you just pretend it said graduates yes, and it says immigration options for college and university graduates, then about 80 or 90% of all the options that are discussed in there are also available to people with a bachelor's degree in whatever. And so you might find that interesting. There's some checklists in the back of different temporary work options and permanent pathways and things that you might find interesting reading. Then there's an article called U.S. Immigration Overview that kind of describes the history of the U.S. immigration system, how we got such a complicated, kind of strange system. And then the last thing, number 4, is from the government. I didn't write this last one, the government did. It's called Working in the United States, CPT, OPT, and STEM OPT. And those are all things that F1s probably already know some things about, but that's just a little piece from the government. Then also I would usually pass around, if I were doing this in person, as I hope to be maybe this fall, maybe in October, but go back to the traditional way of doing it. I pass this around just so people get some flavor, not because I expect them to read it, but just so you get a sense of what the US immigration laws are like. This is in a single volume, some, but by no means all of the laws and regulations dealing with the immigration categories for students and lots of other categories too. It's about 2,500 page book with really little tiny print, but the sentences sometimes go on for, it seems like a half a page. So it's a little dense. But it's just to let you know that a physical reminder that the US has the most complicated immigration legal system of any country in the world. And the only thing in the US legal system, I'm told by other people who are experts in these other areas, that is as complicated as the US immigration laws is the US tax laws. If anybody on the call, I see some people could show of hands, but sometimes people are studying accounting or business administration, an MBA program or something. They take accounting courses. They're maybe even already a CPA or a chartered accountant in their home country. But the tax laws of the United States are famously the most complicated tax rules of any country in the world. They involve lots of forms. They have lots of regulations. Sometimes it's hard to get human beings that will talk to you personally about your case. All that's true of immigration too. It's government, 100% government controlled, and 99% plus is federal government, different parts of the federal government. We'll talk about that a little bit. Then some people have said, oh, Scott, did you write the book about immigration? Well, I didn't write the book about immigration, but this is one of the books that I put together. And I built this book as the editor of this book, the first edition and subsequent editions. This particular one, goes a little later than that, but it's of all the, not all, a portion of some of the forms and instructions for various immigration forms. This is a tiny fraction. If you listed all the forms and instructions that are currently out there, it would probably be the equivalent to maybe 20 of these books. So there'd be thousands of pages. So, and nobody memorizes all that sort of things. We have to look up some form we only use once every 2 or 3 years. We have to double check to see if the instructions changed since the last time we looked at it. And I was also the editor of this book. This is the leading book by the leading organization in the United States for immigration lawyers. It's called Immigration Options for Academics and Researchers. And I was the editor-in-chief of this book. It has various articles, one of which, that Professor Yes article, actually was the first article in this book. And there's going to be a new edition coming out later this year, and it's going to have an updated version of that article in it again. Anyway, so let's start off. We can go to some slides.
Yes.
If you want to start the PowerPoint.
Yes. Just letting you know, for those who attended, joined the meeting late, just to try to keep, please mute yourself during the session. And if you have any question, submit those questions through chat box, and we will go through all the question, hopefully all of the question during Q&A. That's hopefully around after 5 o'clock, one by one. And then we will try our best to go through all the questions. All right. And then the handout that Scott mentioned, I'll be emailing you all later.
Okay, ready for the first PowerPoint. Good. All the people's faces disappeared, but I assume that everybody's still there. I'm looking at a screen that has the PowerPoint, and I can see you, Miho, in the corner. So shall we jump in?
Yes, please.
Okay, let's go to the next slide, please. Okay, so these are the parts, the sequence I'm going to follow today. I'm going to start off with some practical tips for F1 students and graduates as of the way things stand right now. Then I'll give a little bit of an overview. Some of the people, I recognize a couple of faces that have been at prior presentations that I've given. But some have not. And so I wanted to kind of give an update and a picture of kind of what the main moving parts of this big immigration system, machine, whatever you want to call it, in the United States. So then when we start talking about detailed things, it'll hopefully make a little more sense. Then we'll spend some time talking about temporary work options, including all the F1 related options like OPT, STEM OPT, and CPT, and then and some others. And then we'll also talk about the next section before we go to Q&A will be some green card options, different ways that a person could qualify for permanent residence in the United States. Before I jump into that, we'll just stay on this slide page. most people, unless you're really trying to avoid exposing yourself to news, you'd be aware that we have a different president than we had at the end of the year. Joe Biden was elected president of the United States, and Donald Trump is no longer president of the United States. And the election was disputed over one of the main issues was immigration policy. And the Trump administration had put many things into place, mostly by executive orders and proclamations and memos and guidances, and pointing people that had a more restrictive view of what should be permitted for immigrants and non-immigrant visitors in the United States. And that was one of the main battlegrounds of our presidential election in our system. And on the first day that Joe Biden was president, he was sworn in, he was inaugurated on January 20th. That's when he legally, at that moment, they passed the control of the nuclear football, as they call it, and all the control of every aspect of the US government, the executive branches, all legally passed to Joe Biden. And on that same day, he still found time to propose a new law, a major new immigration law that he announced, which, if it's passed by Congress, and the name of it right now, the working name is the United States Citizenship Act of 2021. There hasn't been a final written version that I've seen yet, but I think we'll see it in the next few days. But it includes many things. In one of those things that gets the most publicity is an 8-year path to citizenship for more than 10 million people who are in the United States today that did not have documents when they came in, many of whom came to the United States as children. Then that would be that, together with the other things. One version I had heard of was more than 2,000 pages long. Others have been a few hundred pages. We won't know exactly what's in the proposal until it actually gets officially submitted to the Congress, but there's going to be a lot in it. But if it passes, it would be the biggest change to US immigration laws in one law in the last 40 years, approximately. Some of the highlights are a new system for family-sponsored and for employment-sponsored immigration that would create new, faster paths for green cards and citizenship for many millions of immigrants, more than 1 million a year, indefinitely into the future, as well as those 10 million, undocumented folks. Some people call them the dreamers, entered as children, and as well as millions of people that have been waiting in lines, in some cases for more than 20 or 30 years, following all of the documentation rules to get a legal green card in the United States. But because of quota delays and processing delays, they haven't completed the process. And so a lot of those folks in family and employment sponsored categories are also would benefit if this new law change passes. Also, changing to the U.S. Immigration Court. If people have an enforcement issue with the U.S. immigration laws, they don't just get thrown out of the country overnight. They get a chance to go to court, have a lawyer, and have a trial sort of, and see if there's some basis for him to stay longer, that they can get a work permit and various other things. But right now, there are so many cases that are so far backlogged that there are more than 1.3 million cases. And in some people's cases, they've been, since they were told they were going to be sent to the immigration court, they have been waiting in line for more than a year before they got to go to have their day in court. They would have to hire a lot more immigration judges, which would cost a lot of money, and that's why you have to have legislation. The current judges have unrealistic amounts of work they have to do. Like they're supposed to process 2,000 cases or 3,000 cases a year, which means with others' responsibilities they only have like maybe a half hour, an hour per case, which is ridiculous. So some of the complicated cases can take days. So it creates a real difficulty. There also would be increased spending on border security and instead of a wall, and shorter delays and improvements in the process for asylum and refugee folks. Also, in his first 2 days as president, Joe Biden signed multiple presidential proclamations, executive actions that revoked a lot of the restrictive Trump policies. And these are just some of them. In the first 48 hours of being president. He made the Obama era DACA program, Deferred Action for Childhood Arrivals, which allows many of those dreamer folks to get temporary work authorization and temporary immigration protection from deportation. That was created under the Obama administration. There were lots of lawsuits about it, and it was the thing was speeded up and slowed down depending on who was president. But he put things kind of back to where they were 5 years ago, and that's probably going to continue for the duration of his presidency. And if they pass a new law that's more generous than the temporary benefits, then the new law would take that over. He declared an end to any further construction on Mr. Trump's one of his favorite projects was his construction of a giant wall on the U.S. Southwest border with Mexico. He cut off that because the money that was being used in December and until January 20th to build it was actually taken from the U.S. Defense Department based on a presidential declaration that there was a national emergency of immigration and that they had to use part of the defense budget instead of for soldiers and Navy and aircraft carriers and stuff. They had to use part of that money to build the wall on the southwest border. Well, that's ended. That's already frozen. Then there was a famous thing that was called variously the Muslim ban or the Trump travel ban on people coming to the US from certain predominantly Muslim countries. That ended. Now, when I say that apart from the money for the wall getting cut off, when these presidential proclamations and things are announced, they're announced and they're the official policy of the US. But the US immigration system is really complicated, as I said, and it has hundreds of thousands of people, actually probably maybe more than 1 million people that work for various parts of the immigration system in the United States. And they're all at different levels. And by the time, it takes a long time for things to actually translate into changed behavior, changed actions by the government officers at the airport, at the consulate, at the interview room. So it's going to take months or maybe years to get things back to mostly where they're trying to go with it is reverse most of the negative restrictive things that were done by Trump presidential proclamation. And then putting new things in place will take longer. Passing a new law will take quite a bit longer, probably months or years before they even vote in Congress on a big new law change. They also extended protections for certain people from Liberia in the United States. Minnesota has more people from Liberia than any other state in the United States. And then there was a program that there was a lot of problems with called the Remain in Mexico program that was put in by the Trump administration, which forced many thousands of people that were showing up at the US border in Mexico and were trying to apply for asylum or refugee status for themselves or their families. And they say it used to be, before that Remain in Mexico program was put in, they would be allowed into the United States temporarily in order to go to immigration court. Well, they said, no, we're not going to let you come into the country to go to see an immigration judge or process an asylum claim. We're going to make you wait outside the country. But they didn't provide any provision for it. And a lot of the people are living in very dangerous conditions in that area. So that's suspended. And they're in the process of trying to, there are no more children in cages, try to match people up, parents and children that were separated. That's going to take a while to get that straightened out, but that policy is over. And then also there was a 2017 Trump presidential order through the Attorney General that made it a top priority for enforcement of any undocumented person would be arrested and detained if they even found a small violation of the immigration rules. This is not uniformly applied, but it gave a permission to the local police to just call the immigration service, said this person got a speeding ticket or some other violation and they're not a US citizen. Do you want to come and get them, or do you want us to take care of it? And some places in the United States, not in Minnesota very much, but the immigration services say, we'll come over and pick them up. Just keep them in detention there, and then we'll put them in immigration detention and do the paperwork on that. So that is ended now. So that's no longer a priority. One of my favorite things that he announced that he was intending to do is he wants to change the one word in the US legal system, in the immigration laws, but it's a word that shows up thousands and thousands of times. And that is the word alien. If I ask most people, at a informal conversation, and said, well, do you know what an alien is? Yeah, and they say, well, an alien, yeah, I do. That's somebody from a different planet. And that is the word that our law uses to describe anybody that's not a U.S. citizen. That includes green card holders that have been here for 50 years. They're still referred to as aliens. And other countries have also not so charming words to describe the people that aren't citizens of that country. I think in German it's called an Ausländer, or outsiders and insiders or whatever. So, but they would replace that. So everywhere it says alien, it would now say non-citizen. We'll see. I'd like to see that happen fast. Specifically related to OPT and F1 students, there are several people on the call that are on OPT, and a lot of others that are probably going to be on it in their future. Is one of the last things of the Trump administration, a week before he was leaving office on January 13th, there was an announcement that they were going to set up a special enforcement compliance unit in the part of the immigration system that oversees all of the F1s and all of the OPT, the SEVP. And that is, it's basically to go and visit students that were on OPT, or employers that had people on OPT, and schools that were authorizing people for OPT to make sure every single thing was exactly the way that they wanted it. So they were doing like live audits. And that was put into effect on January 13th. And then on January 26th, 6 days after Biden became president, he said, yeah, we're not going to do that. There's no money for it. We don't need to do it. So that's dead. So that's nice because you can exhale a little bit on that one. One other thing that's changed on January 8th, if you apply for OPT or STEM OPT, you have to file a form I-765, and they change the address. And this can be an unforgiving system. If you send the right form with the right fee made out to the right government spelled name agency, but you send it to the wrong address, which was the correct address in December, but you use the old address listing, then you maybe didn't get anything. And so, and by the time you figure it out, since it can take them months before they even look at these things, and they're even months behind in issuing receipts for things. So, well, the fact that you say, well, I didn't get a receipt. Oh, that's all right. We're behind in our, opening our mail. And so that, don't worry about it. Well, some people should worry about it because you sent it to the wrong address. And then by the time they figure it out, then it's too late to reapply for OPT because there's a short window, 90 days before your graduation or completion of studies, or 60 days after. And if you apply before then or after then, you don't get any OPT for that round. But so make sure you go online to the uscis.gov site just before you send in your I-765. They could change the address again. They move them around from time to time, and make sure it is the correct current address. Okay, next slide, please. Okay, these are some quick takeaways that for everybody on the call. I had 7, and then after I sent this to Miho, I came up with 2 more. So it's going to be 9, but they're not on the slide. So number 1, for most people, the best advice is to stay in school, maintain your F1 full-time student status. Don't drop out of school if you can possibly avoid it. If there's certain things like health problems and stuff, and then you could speak to your international designated school official, and then say there are circumstances where you can get permission to take a reduced course load, or even not take classes at all, and not lose your F1 status if there's a little interruption. But don't assume that, of course, somebody will understand. There'll be a reasonable person that will say that this is all okay. As soon as you know that you have a potential issue, you should talk to your international student advisor as soon as possible. And then there are lots of F1 rules. Most people that are F1s have not read all the F1 regulations. I'm not suggesting that you do, but the rules that you do know about, follow them carefully. And so here are some of the main things that people can do to create a problem. One is working without permission. don't work without advance written authorization from the school or the immigration service, or in some cases you need both. Don't even do it a little bit. Doing a little project, if you happen to be a musician and somebody wants you to give them some music lessons on piano or whatever, and you get paid cash and nobody gets any tax consequences, they think, that's still considered to be unauthorized employment that could create a problem for your eligibility for OPT and your eligibility to stay in the United States if the government becomes aware of it. So number 4, don't travel outside the United States. If they're without checking with the international advisor, or if you have a personal immigration lawyer, talk to them first and say, I'm thinking of doing this because it's an important family event, a wedding or whatever, or a career opportunity. I've got this all expenses paid trip to go to Paris and go to this conference and with a scholarship. And said, don't do that without knowing in advance what the immigration consequences could be. Just because you have a round trip ticket for 7 days or 2 weeks, that doesn't mean that you're necessarily going to be back in the United States. Even if you have a green card and you leave the United States and you think you're going to be able to get back in 2 weeks or whatever, you might not. You can be, there are people that are getting stuck outside the United States. They have trouble getting into the US consulates, many of which are closed, and the ones that aren't closed are still backlogged because they have so many backed up applications over the virus and everything else. So you're taking a bigger risk than usual by travel. Any international travel, if you have a visa that's still valid for another 2 years, if you leave the United States, you still have to get screened and be allowed to board the airplane to come back. And once the airplane lands, the immigration people at the airport decide whether to let you in or not and for how long. So if you want to avoid the risk of a problem or delay there, just don't leave. If you're majoring in a STEM OPT field, a STEM OPT field is optional practical training in a science, technology, engineering, or math field. There's a list of them by zip codes. A zip code, CIP code, is listed on everybody's I-20. And there's a periodically updated list of number codes, and most occupations or most fields of study that have anything to do with science, technology, engineering, or math are on that list. They've added every few years more fields to the list. And I don't think they've subtracted many, if any at all. But to have the eligibility for the STEM OPT, normal OPT is 1 year after you complete your studies. So bachelor's, master's, PhD, whatever it is, 1 year. And then you have to switch to something else. And H1 is a common choice if you can do it. But if you are majoring in a STEM field that's on that list, then you can get 2 more years of OPT. And since there's a lottery and there's competition for the H1s, and the chance of being selected if you have a bachelor's degree only is probably about 30 or 40% at best in the lottery. That means 2 out of 3 people that tried to go through the lottery this year or tried to go through last year are not going to get selected. So you might have to try more than once. 2 or 3 times is not unusual to try to go through the H lottery. So you don't want to pass up a chance to apply. And if you have STEM OPT eligibility, while each year goes by to retry for the next H1 lottery in March of 2022, how do you stay here? How do you keep legally working here for an employer that you might like, that's good for your life and career? You apply for STEM OPT, and you're going to have a good chance of getting approved for STEM OPT if that is listed as your major. So and if you have a joint major, that's probably okay. But if your long-term career interest is in a STEM field, it's better if you're at least a joint major or a sole major and something else is a minor that's on the non-STEM part, just because of bureaucratic reasons, not because it's a good or bad thing to do. Then number 7, when looking at potential H1 employer sponsors, it's to improve your chances of approval. You want to go for the highest salary possible because there are salary requirements for H1s that don't apply to OPT. and the higher the salary is relative to the average salary for that kind of job in that part of the country, the greater the chance that you'll be approved. So if you have a choice of a job as a accountant in South Dakota or Minnesota, rather than in San Francisco or New York City, the salaries are higher in San Francisco or New York City, and so maybe there's, harder to get those jobs because they pay more. If you take the lower paying job, but it's high relative to what other people get paid in Duluth or wherever, in that job, that's good. That'll improve your chances. So then number 8 that's not on there is I recommend you apply for OPT as soon as possible. And currently, I believe the rule is still 90 days prior to completion of studies or graduation. If there's a difference in time between when you've finished all the requirements to graduate, and that might be, say, on May 10th, you have your last final, you passed, and you've met all the requirements, you paid all your tuition, there's no loose ends, you're just waiting until the big graduation ceremony that's on May 28th or something. Your completion of studies date is the date you satisfied all the requirements for the degree. And the reason you might want to choose that earlier date is it might be 20 days earlier. And the sooner you apply, the sooner you get the employment card for OPT. If you wait until later, that's fine. If you wait till after the graduation ceremony, that's fine. It's just you're going to be that much further in line behind all the other applications, which are heavily backlogged at the moment. Okay, then if you currently have a job or a job offer now, right now, in the next 2 weeks is the best time to talk to that employer about sponsoring you for an H-1. Even if you don't have quite completed your bachelor's degree, if you are expecting to get your bachelor's degree before the end of May or early June, then it is okay for you to have the employer try to sponsor you in the H-1 lottery, as long as you will have the degree by the time the petition is adjudicated, which is several months later than when the lottery is. So, and also, if you had a bachelor's degree in another country, you got a bachelor's degree in Canada or some other country in the world, and that it's related to your career plans, you can use that bachelor's degree from another country as a basis to participate in the lottery, even though you've still got 2 years left on your master's degree program at St. Thomas or whatever school you're at in the United States. And so the more chances you have at the lottery, the better. So it's worth talking to your employer. If you haven't already had a conversation with a current employer, say there's this window of opportunity. And if you miss this window to try for an H-1 that's subject to the quota, which most H-1s are, then it won't come open again for another year. So, and even if it's you want to try to do it again now or another year, after the lotteries and you win the lottery selection and then you get an approval, it doesn't turn you into an H-1 until October 1st at the earliest. So if people who are applying in this year's lottery will not become H-1s until October 1st of 2021. And if you wait until next year to participate in the lottery, you would not become an H-1 until October 1st of 2022. And at some point, OPT runs out. And the best alternative for Plan B, if you don't get selected in the lottery and you run out of OPT eligibility, for most people, the leading choice, if you want to stay here and keep working here, is to go back to school and get another degree. Preferably, probably at the same or higher level. Like if you get another master's degree, hopefully it's not a waste of time and money, and you're just doing it to maintain your status in the United States and get a little work permission on campus, or you can get something called CPT to work off campus in the job that we were working on post-graduation OPT, and the employer wants to sponsor you, but you just weren't lucky enough to win the lottery the first try. Next slide, please. Okay, so the US immigration system divides every person on the planet into 2 categories: citizens and what I will call non-citizens. They still call them aliens under the rule. And the aliens are further subdivided into people that are immigrants planning to come to stay permanently, and non-immigrants, people who are planning to come and just be here temporarily. F1s are all considered to be non-immigrants. if you're an F1, but you're really planning to stay here permanently, then if that was your intention from the beginning, somebody made a mistake at the consulate, because they're not supposed to give temporary visas to people. An F1 is not a live here visa. It's a temporary student visa. It's a visit for a long time to study. Immigrants, the US has a rule, which is the main rule that is used to reject people for F1 visas worldwide for my whole career, and for visitor visas, that says everyone in the world is presumed to have a permanent intention to stay and live and work in the United States, or not necessarily work, but to live permanently in the United States, even before they even open their mouth, before they ask the first question or answer the first question. And that is called the 214B rule, the rule that all people in temporary alphabet categories except H1s and L1s have to have only temporary intentions when they apply for a visa, when they show up at the airport to come into the United States, and all the time they're here as an F1, F1 OPT, et cetera. And so the government doesn't have to prove that you have permanent intentions. The law presumes you have permanent intentions, and you have to prove the negative, that no, I don't have permanent intentions. And then the consular officer or the person at the airport say, well, I'm not convinced. Yeah, the answer is no, I'm not letting you in. So statuses and visas. The government confusingly uses the same alphabet system to classify statuses and visas. There's an important legal distinction between an F1 status and an F1 visa, or an H1 status and an H1 visa. If you're in the United States, it's most important that you be in status, following the rules for a person who's in the United States in that category. Your visa can expire and your status is still good. You also can have a visa that's still good, even though your status has expired. Anyway, so what all that a visa does, it's that thing that they put in your passport with your picture, issued by the US government to the consulate, and it allows you to come to the border and try to get admitted and try to get a status. It's an initial step toward getting a status. It is not the same thing as a status. Next slide, please. One common misunderstanding about the status things is that, forget that part. Temporary statuses that have some type of restricted employment authorization are HL. There are different kinds of TN for Canadian citizens and Mexican citizens, E category, OR, F1, and the various OPTs and J1. There are hundreds of other categories, some of which also have work authorization that's on a restricted basis. It's a restriction limited to a particular employer at a particular work site for a particular job, in the case of an H1 or an H2 or an L1. In other cases, it has other restrictions. Some people have unrestricted employment authorization, such as people who are registered under the DACA program, or an asylee applicant that gets a temporary work permit, or a person is married to a US citizen and they have a pending green card case that can take a year or more to complete currently in Minnesota after you get married and file the papers. But people who are pending applicants for that green card, they get issued an unrestricted work authorization that can be used for any job in the US economy. And then there are permanent unrestricted ones, and that's for people who have green cards, and these are all called US workers, green card holders, refugees, and asylees. Next slide, please. Okay, so as I said, the common misconception is you can have a valid visa and not be in a legal status. If you're confused about this, that's a good thing to have a mini about, to explain, maybe you don't have a problem, you're just worried unnecessarily, or maybe you have an issue that you didn't think you had. So it's possible to have a valid status and an expired visa, and it's also possible to have a valid visa but not be in a proper status, such as by working without authorization. All the papers are okay, my visa is okay and everything else, but your status is no good because you worked without permission. It doesn't require government intervention for you to be out of status. Next slide, please. Okay, these are the main government agencies, not by any means all of them. And there's subparts of these various government agencies. These are the three main agencies that deal with immigration things that, as an immigration lawyer, every day we deal with all three of these agencies, and there's subparts one way or another for somebody. In addition, There are hundreds of other parts of the federal government that we deal with only very occasionally, but depending on the person's occupation and their situation. We might be dealing with the U.S. Department of Agriculture or the Department of Defense or the Department of Justice, or all kinds of different things. But for the most part, the main immigration stuff is here under the Department of Homeland Security, which has its main subparts, the USCIS, U.S. Citizenship and Immigration Services. And that's mostly where you go if you apply for a work permit or a green card inside the United States. Those are the ones who have the benefits. They're not primarily oriented enforcement. They make decisions to approve or deny cases based on the facts and the evidence. And if they say no, that can have consequences, but they're not the enforcement people itself. They work with the enforcement people. It's one of the enforcement people that one branch of the Department of Homeland Security that deals with enforcement is the people that work at the airports and land borders with the uniforms and sometimes they wear guns and whatever badges. That's Customs and Border Protection. And their job is to screen people to decide which people are, whether the people are who they say they are, whether they seem to be telling the truth in answer to the questions. And if they are eligible to be allowed to set foot in the United States. Only category of people that are entitled to come into the United States are US citizens that have proof of their identity and their US citizenship. So a US citizen with a US passport is entitled legally to come back to their home country. A French citizen with a US green card is not entitled to come into the United States. They're still considered an alien, a foreigner, a non-citizen, and it's up to CBP to whether to let them in or not. In most cases, they will let those folks in, but they can ask them questions. So while you were in France, did you get any speeding tickets or DUIs or anything? If they have any reason to check into something like that, that could make that person have a delay or make them not admissible. They might have a right, usually would have a right to go to an immigration court and say, well, no, I think the person at the border was too strict. This shouldn't apply to me. But you're not guaranteed to get in unless you're a US citizen. ICE and Customs Enforcement, or ICE or ICE, is Immigration and Customs Enforcement. That's the enforcement. They call themselves the Immigration Police. And they are the ones that go out to the jails and they detain people for immigration purposes that also have other legal problems. TSA are the people at the domestic airports. If you're getting on an airplane in Minneapolis to fly to Chicago, those people that with the security screening and so forth, and you show your documents to, they're part of the Department of Homeland Security too. And they have access to information about your history. As soon as you give them your identifying information, they could look up on a screen and say, oh, this person's an F1. They last entered in Detroit 2 years ago. And it says that they're listed as a foreign student. Just for the heck of it, I'll ask them a question. What school are you going to? School? What school? I'm not going to school. Okay, come over here. I have some more questions for you. So they also work in the same agency and they share information. Department of Labor has a special role with H-1s and with permanent sponsorships for employers. And the Department of State controls all the embassies and consulates. And so when you go to a consular interview, they're applying immigration laws, but it's not the Immigration Service. Next, please. Okay, so recent trends is they've been applying more restrictive adjudication standards and more strict enforcement. This hasn't completely stopped, but I think over the course of the next months and years that this is much stricter under the Trump administration than it was before. I think some of this will change without having to change the law in Congress, just changing the leadership at the top and having a more kind of balanced approach to enforcement rather than looking for reasons to get people into difficulty. Next, please. Thank you. The extreme vetting is they can ask to see your, they ask for a password to open your computer or your cell phone. And you say, I don't want to give you my password. And he said, oh, that's fine. You don't have to give me your password. But if you want to come into the United States of America, I have to say yes. And I guarantee you, I will not say yes unless you let me see your computer information. And so, well, suppose I don't want to let you do that. I said, well, then my decision is no, you can't come in, even though you had made 5 trips into the United States before and you're F1, and I believe that you're going to school, but I am not going to let you in because you did not cooperate with my reasonable request for information, and you don't have the right to keep that private if you want to come inside the United States. And they don't do this to everybody, and some of it's random, and some of it they mistakenly over-identify people of interest. But anyway, it's just so that they can do that. Next slide, please. Okay, so temporary options. There are many, many ways, in addition to what's listed on this slide, of getting work permission in the United States. These are the most common ways for people, in my experience of 35 years and tens of thousands of people that I've talked to. This is the most common pathways, regardless of what country of citizenship the people are, that are used as work authorizations. For people that have at least a bachelor's degree from the US or some other country, an H1 is the most common choice. And H2B and H2A are for lower skilled workers, and they are more limited and require proof of shortage of workers. I just list them because they're widely used. There are quotas for H1s and H2s. J1 category is cultural exchange visitors. There are J1 students. There are also more commonly J1 graduate students and postdocs and people that come here as au pairs and summer camp helpers and things like that, and trainees. There are lots of subcategories within J, but that's another pathway that's sometimes available. L1 and L1B, multinational transferred key employees, executives, managers, specialized knowledge workers, all defined terms under the immigration rules. So if somebody worked for 3M for a year before they came to the United States, and they've been a student here for 2 years, but they worked for a full year for 3M doing something in Italy, and now they want to work for 3M again in the United States this time, 3M doesn't have to go through the H1 lottery. They could sponsor that person as a transferred worker if the person they're transferring or trying to transfer into this L1 work permission has had at least 1 year of full-time experience in one of these key categories of jobs for an 3M affiliated company outside the United States. O1s are for people of exceptional ability. It's far above average in any field of business, arts, athletics, whatever. There are some country-specific special work permissions that are available, and I don't have everybody's nationality, but if anybody on this session is a citizen of Mexico or a citizen of Canada, you may be eligible for a TN, and that could be a nice backup if you're not picked in the H1 lottery. There's some advantages to an H1 compared to a TN, but having a TN is in many cases better than OPT. And it's 3 years if it's approved, and it can last for be multiple renewals. E3 is sort of like a TN for people from Australia. The H1B1 is sort of like an H1, but for citizens of Chile and Singapore. E2 is for employees of a treaty investor company. There are more than 80 eligible countries that have treaties with the United States, and that could be manager, executive, or a key employee. Next slide, please. Permanent options. Some of the options for green cards require labor certification and some don't. It's important to remember which kind you're working on. Next slide, please. Okay, now we're going to go more detail on the temporary options. L1 I already explained. You can read this later so we can get through the rest of the slides and get to the Q&A here. So, but there are significant advantages to an L1. If you have a choice of being an L1 or an H1, and it's particularly if you have a choice of being an L1A or an H1, it's usually better to try to go the L1A route because it leads in very nicely to a green card sponsorship without having to prove a shortage of US workers. Next slide, please. TN, I mentioned you have to be a citizen of Canada or Mexico. As the core elements are, it has to have a temporary intention. It's that same because this person's an alphabet category and has to have temporary intentions. And the position they're offered has to be a specific listed occupation. This is sort of like the STEM OPT list. You're either on the list or you're not on the list. There's not a lot of gray, fuzzy stuff here. Is the occupation engineer on the list? Yes, it is. Do you have an engineering degree in US, Canada, or Mexico? Okay, you're potentially qualified. Up to 3 years renewable, and there are pathways. You can either get it at the border or go through the consulate. Next, please. So going back to the permanent options, there are different subcategories. You see at the end of most of this the ones under the first group, there's EB2, EB3, EB3. Those are immigrant visa quota number categories. They're varied by country and by category. An advanced degree is an EB2. That's a higher level with more numbers available usually. That's the position. And this is for requiring labor certification, requiring that labor market test. So an advanced degree position requires a master's or higher degree or a bachelor's degree plus 5 years of progressive experience. And that gets you into the EB2, which is a higher category, and there are advantages to that. A professional position is a position that's like an H1 entry level position. That's an EB3, which is still, it's better than being an other worker, which is at the bottom of the list because the quota numbers are available. The other worker category is a job that requires less than 2 years of preparation, which could include 0 years of preparation, 0 time of preparation. The waiting list for green cards for employers that prove a shortage of people to work as a waiter in their Vietnamese restaurant, and you have to be able to speak Vietnamese to talk to the chef and a lot of the customers. This is that category. If you go through all the employer goes through all the approval sponsorships, the line, depending on what country you're from, could be 20 years long. So the prospects for lower skilled occupations are not good. If you're at University of St. Thomas and you either already have or are in the process of getting at least a bachelor's degree, you have dramatically improved your opportunities to get a green card. The position has to really require whatever specific education the employer lists on the labor certification process application, and the person has to have all those credentials already accomplished before they go to work for the employer. Next, please. Okay, and with the labor certification, the good news is that while it can be expensive for the government filing fees for the process and for the legal fees and the advertising and recruitment, the good news for you as a candidate is you don't have to pay any of it. The law says the employer has to pay all of it and no contribution, not take it as a safe payroll deduction. Oh, we spent thousands of dollars getting you your labor certification and your green card. So, you have to pay us back. No, you don't. And they can't ask for that. That's improper. And so that makes sense. Great. I don't have to pay for it. The bad news is that makes employers more cautious and more reluctant to sponsor people because it's going to cost them some money. So, and there's this Department of Labor controlled process of the employer has to go through, almost always with the assistance of an experienced corporate or business immigration lawyer, to go through all the documentary steps and the actual interviewing steps and so forth of the other candidates that apply to make sure that they can show that the employer, in a good faith, honest way, tested to see if there was a shortage of US workers for that particular job with those particular credentials in that particular location at that particular time. The research part of it takes usually about 2 months when they have to be running the ads and recruiting, and then they can close the application window. And somebody applies after the application has been submitted to the Department of Labor, the employer doesn't have to consider them, even if they're fully qualified. It's a very nitpicky process, and the people that try to do it, it's impossible. It's against the rules for the sponsored worker to have any role in the labor certification process whatsoever. Because they're afraid that they would, if they were interviewing, you're interviewing somebody to take away your job and stop you from getting your green card. They think not many people would have an incentive to be nice to those candidates. So that's just prohibited. The employer gets to control it. The employer can have a lawyer to help them with the process and the compliance and improve the chances of success. And that same lawyer can be hired to also represent the sponsored worker at the same time. But the employer controls the choice of lawyer for labor certification and also for an H1, and the employer controls the content of the documents that the employer signs. We help prepare them, just like if I haven't done one of these in almost 40 years, but I used to do some other kinds of law, like write a will for somebody. I will draft the will based on the information they gave me and their requests, but I can't sign it for them. They have to sign it. They submit it, it's going to be their document. Same way the employer has to sign the documents for the labor certification, and they have to sign the documents for an H1 sponsorship. Next slide, please. Okay, so I mentioned that the L1 has this big advantage because it overlaps very significantly with the transferred executive or manager green card. So if you can qualify for an L1A, you probably also can qualify within a short period of time, within a few months, to apply for a green card based on the exact same job that you're in. It has the same requirements. I use the 3M example. If you met those requirements at that time, you still meet those requirements, you could apply to go straight for the green card. No advertising, no proof of shortage, no Department of Labor saying what the minimum salary has to be. And it's in the highest category, the EB1 category, the top tier. If it's the airplane, this is the VIP business class with the seats that lie down so you can take a nap, compared to the class I usually sit in. So next slide, please. Okay, so there are more green card options that I don't have time to talk about today. Of the about 1 million people per year on average have gotten legal green cards in the United States every year since I got out of law school about 40 years ago. The most of those million people qualify on family-related options, and only close family members are eligible to sponsor people. Some of these categories are quota exempt. There, for example, if every person who is not married right now that's legally eligible to get married, they're 16 or 18 years old or wherever, and let's say there are 100 million of those people that are not currently married at various ages. If every one of those people decided that they wanted to marry somebody from China next month and they got married, then all 100 million of those spouses of US citizens would be eligible to get green cards. That's not going to happen that way, but there's no quota based on marriage to a US citizen. There is a quota for marriage to a permanent resident. There is a quota for brothers and sisters of US citizens. There is no quota for parents of US citizens. So there are just a couple of immediate relative categories that are quota free. That doesn't mean it's necessarily simple or fast, but it's quota free. All the other categories except spouses of US citizens and parents of US citizens have quotas. The backlogs, I talked about the backlog of the unskilled workers, the other workers category, the bottom of the employer-sponsored labor certification categories, and how long the wait was there. Brothers and sisters of US citizens, backlog for that can be 20 or 30 years. So if a person who is an adult now that's on this call, that's 20 some years old and is just starting their career, and they go through the H-1 process, and a few years later, they manage to get a green card through an employer sponsorship. And then 5 years after they got their employer-sponsored green card, they can apply for a US passport, become a US citizen, and then they can file a petition for their brother or sister, or more than one. And then from that date, which is 7 or 8 years more in the future, from that date, that's where you start counting the 20 or 30 year wait. So if you're sponsoring an older brother or sister and you're now 30 years old when you file, and your older brother or sister is 40, they're going to be 70 years old. Maybe they won't want to come. They won't want to wait that long. Anyway, but over half of those million cases are in those family categories under the current law. One of the proposals in the Biden category would be increase the total numbers and increase the amount of numbers for people that are caught in these backlogs now, and also for employment-sponsored folks who get a more limited number of the total 1 million or so per year. Then there's one of the categories is green card lottery. Everybody who is in or out of the United States that's an adult could potentially apply for the green card lottery, but there's some countries that they decide year by year are not eligible. And countries become not eligible for the lottery, not because the United States has bad foreign relations with them, like they're North Korea or someplace. They do that based on how many of the regular other green card categories people from that country used in the preceding year. And some countries, year after year, always use the full amount of their quota of all the quota categories. For example, you would no surprise that the two largest countries in the world, India and China, which account for over half of all the human beings in the world, account for a significant portion of all the people that would use all the other categories. And they've never been eligible for the green card lottery because they use so many of the numbers from the other categories. But there's some other countries. We have great relationship most of the time with Canada, and Canada is on the ineligible list. Can we go back to the prior slide, please? Thank you. One more back. There we go. Perfect. Okay. Canada uses a lot of both family-based and employment-based and investment-based things, but they're not eligible for the visa, the green card lottery either, because their numbers are too large. The UK, I think most years, Ireland, Mexico, and other countries, it kind of varies from year to year. I think Brazil now is, I think, on the non-eligible list, but there are about 200 different countries in the world. And there are probably, in any given year, I think there's probably at least 150 of them that are eligible. Then there are investment-based options, usually require a lot of money, or at least a family business that has a few employees outside the United States, somewhat established, then could open up a branch or a subsidiary in the United States. Usually the amount of money that it takes to do this and have a credible chance at it with any of the investment-related strategies is probably at least $200,000 US that can be invested in the business operations in the United States, and probably have to hire one or two at least part-time employees, including not counting the person that's trying to get sponsored. Then there's some opportunities for entrepreneurs. People want to start their own businesses. And then there are some special options in the employment-based categories, as well as the labor certification, extraordinary ability, exceptional ability, college and university faculty. So if I took out the green card lottery, I took out the family-based categories, there also are some for political asylees and refugees. And the only thing I was left were employment-sponsored green cards using labor certifications or some of these special categories. You think, my gosh, there's almost nothing left. Well, a lot of the numbers are used for those other things. But in my practice, I've been doing immigration law now for almost 40 years. And and we do family-based cases too. But over the last 40 years, by far, the greatest number of people that I and the people in my office have helped get green cards did not come through family pathways. They came through pathways based on their education, their skill, or their investments. That's the nature of our practice. And the chance of success for any individual is kind of merit driven by your accomplishments, not who your relatives are. So people, and in general, the more education, this is my little advice that I give to my son, give to my grandchildren now that they're in high school, and anybody that asks, and some that don't, about, what's the secret to a good career? So, okay, number one, get a good education to get a good job. To get any kind of a job, get an education. If you want a good job, get a good education. If you want a great job, get a great education. So anything, whatever your dream is, whatever your career path is, try to do the best you can at education and in your career. So it will never hurt you in terms of immigration eligibility to have additional education in your field. Never hurts. At most, it makes no difference, or worse, it makes no difference. And often it helps. And if you get a job that pays you twice as much money as the other job, that's going to help too. That will improve the approvability of certain immigration applications. Then there's certain kinds of pathways that are favored over others. If one of the options for you is nursing, get a bachelor's degree in nursing, get a registered nurse license, and you have a faster pathway to a green card than the normal labor certification. It's exempt from labor certification because there's been a shortage of registered nurses in the United States for my entire career, and it's getting worse. And the average age, I think, of a registered nurse in the United States right now is probably around 50 or something. And some of them want to retire and spend time with their grandkids or whatever. And some of them get, a back injury and they can't work full time anymore, even though they like it and they want to keep doing it. So if you want a career, what career should I choose? What should I major in if I want to get a green card? Well, that's one option. That there are jobs available. You don't have to prove that. There at any given time, there are probably vacancies right now in the United States for a couple 100,000 registered nurse jobs in any city, any state in the United States. And if you're willing to move there and the licenses are pretty portable, then you can do that. That doesn't mean you have to be a registered nurse for the rest of your life. I've represented lots of people that registered nurse was their pathway to a green card. And then while they were working as a registered nurse, after they got their green card, they started studying at night. They went back to school and they got a master's degree in biochemistry. And then they decided to apply to medical school, or people that went to graduate school after that. It's not one of the nice things about the US system is you don't kind of get slotted at age 12 or 13 or 19 with a big test, and then that determines your whole future. You can get a second chance. You can build a new future. Even I went to law school with people that were 50. So anyway, next slide, please. So again, same thing with the practical tips. Yeah, yes, Miho?
Just letting you know, Scott, it's already almost 5:15.
Yep, I've got it. I'll just finish this one and then we're going. The Q&A is the next slide.
Sounds good.
Okay, so just to remind you, the tips, follow all the immigration rules. One of the most important ones is never give any accurate information to the government on any form or any spoken conversation, whatever it is that's so embarrassing. Oh, I got a DUI, whatever. I don't want to tell them. How will they find out it happened in Canada? You should tell them anyway. You should consult an immigration lawyer about how to tell them in the way that does the least damage. But giving false information on a form or an answer to a spoken question by anybody in the immigration process, at the consulate, at the airport, in an immigration form, an application for OPT, it causes very serious harm potentially. And so just don't, just always give the most truthful answer, the best you know at the time. If you don't understand the question, then you might want to consult somebody to get some help about what is this question really asking about? This is what happened to me. Do I have to answer yes or no? Because sometimes they don't ask for an explanation. They just say yes or no, I have been arrested, or something like that. So did I get arrested or not? So again, minimize travel. If you're going to travel, check with somebody first to make sure that you're not taking in a bigger risk than you think you are about not getting back when you want. Consider possibly, if you have an interest in a STEM OPT area, consider making that a major. A more generalized field like a bachelor's degree in general studies is very difficult to get an H1. It's bachelor's degree in business administration is better than general studies, but it's not as good as a bachelor's degree in CIS or immigration, or let's say there's what's a quantitative thing, and there's a math kind of based track, or bachelor's of business administration with a finance or marketing focus. The more specific, then you can match, and that's it. So next slide, please. Oh, the fun starts. This is my favorite part of the presentation. So Miho,
Yes.
you ask me the questions and I'll try to give as many answers as I can.
Okay. All right. So at this point, I'm going to stop recording. Thank you very much, Scott. Thank you for the presentation. All right. Okay. Did I?
I can see you and I can hear you.
Yeah, hold on a second.